Okay, good morning to all. Today we will start our session on forensic medicine. Good morning. So before we start the session, I always start by saying few things. Legal procedure. So we're going to start with legal procedure. So today the plan is going to be like this. We will start with legal procedure. We will go ahead to thanatology, and then we will do a part of traumatology, medical jurisprudence, and then very small topic in toxicology. So that tomorrow we can again start ahead with toxicology. Okay, morning fresh tomorrow we'll start with toxicology. Let's start with legal procedure. So we are going to see this particular case. Two friends, Khadi and Buddy, returning home. They were encountered by a Don. Don stabs Khadi, right? Buddy becomes the witness. Everything is witnessed by Buddy. Inspector Sherlock Holmes comes, takes the body for autopsy, and we as doctors, we are Dr. Watson, right? We do the autopsy. Okay, so let's see it. We are going to see what type of crime it is, what type of offense it is, right? Who's going to try it, how we are going to be there as a part of recording of evidence, right? That's what we're going to see. Offenses. Yeah. So offense is an act of commission. So someone either is doing something, it's an act of commission, or act of omission, which means the person is not doing something, right? It's an act of commission or an act of omission which is punishable. So if there is an act which is not punishable by the law that's there currently in our country, then it's not an offense. Okay, so offense is anything that is an act that is done or an act that is not done, but it is punishable under law. That's when we call it as offenses. Okay, now there are two types of offenses. One is a civil offense, another we call it as the criminal offenses. Now criminal offenses are offenses which are dealt in IPC, today in BNS. Okay, so they are defined there, their punishments are given in that. Let's take up the examples, then we will come to know what happens with each of it. Murder, rape, these are all considered as criminal offenses. Whereas if you see civil offenses, it will be with respect to intellectual property, divorce. All of these are considered civil offenses. Now, in criminal offenses, there is going to be an individual, and what is happening to this individual? He has done an offense, and for this, the state will take up the responsibility to fight. The state will take up the responsibility. The government will take up the responsibility to fight. Because what happens, let's say a guy does a murder, okay, and people want to compromise outside, or they don't want to file a case, the person doesn't have a relative or anything like that, offense gets unnoticed, right? So what happens is, whenever there is an individual who has committed an offense under criminal cases, the state will take up the responsibility and the state will fight it. Okay, whereas in civil cases, divorce and all, it is a individual versus another individual, right? An individual fights another individual. So what is going to be the punishment? In case of criminal offenses, the punishment can range from a simple fine to imprisonment to even death sentences, right? They can also always give directions. Directions means do this, do that, right? Those are all called as directions. Now, in civil cases, they can give mainly fine, which it's actually not a fine. You can call it as a compensation. So, a monetary compensation is given, and another thing is directions can be given. Give this particular property back to him, give this particular this thing to him. Those are all directions, right? They give directions. Now, laws that come into it. Previously, we had IPC, Indian Penal Code. So now remember, offences which have been committed before the implementation of BNS will still be dealt in IPC only. Okay. Now today you have BNS, Bharatiya Nyaya Sanhita. Now what does it give? It defines the offense, it tells what are the acts which should be considered as an offense, and it gives the punishment for it. It gives the punishment for it. So it defines what is an offense and it gives the punishment for it. Okay. Now we have the definition, we know the punishment. How are we supposed to catch the person? Who can try the case? Like, how much force can be used to, apprehend the person, examine the person, all who can be called as a witness? All these are all predominantly given in CRPC, which was Criminal Procedure Codes. Today we have BNSS, Bharatiya Nagarik Suraksha Sanhita. Bharatiya Nagarik Suraksha Sanhita. Okay. Now, apart from it, not only telling like, okay, you have an offense, you have the punishment. Now you have to define like which all evidence can be allowed as relevant, right? Admissible in the court, right? Now, for that only we had Indian Evidence Act. Okay. Today we have Bharatiya Shaksha Adhinya, BSA. Okay, BSA. These are the laws with criminal offences. Now, what about the civil offences? In civil offences, what did they start to do? In civil offences, there's mainly tort laws. Tort laws means previously we have dealt with a case like this. Hence, this time also we will give a case like this. Now, since you guys are all preparing for NEET, you would already be knowing it. If one person files a case and asks in the courts that like, okay, I want the particular exam to be admissible, the rest all of them can go and get the same judgment. One person goes to the court and says that like, oh, see, I have written this exam, I have become eligible, and today the government has decided something so and so, allow me to be eligible. Everyone else can go and follow him and ask him. So that's tort law. Based on one judgment, we are going to ask the next repetitive judgments. Okay. Okay. Now, this is offense, right? Now, let's go into the type of offenses. What are the types of offenses? Whether the person can be arrested by the police or not directly. That defines as cognizable and non-cognizable. Now, cognizable means the offense is so big, so huge, the person has a cognizance of it and the police can arrest without warrant. Okay. Now, here what can the police do? The police can arrest without warrant. Here, the police needs warrant. Now, we can always give an example, right? Now, here, cognizable, again, example would be something like a rape or a murder. Whereas non-cognizable can be a simple hurt. Two people had a fight and they just slapped each other. It's a simple hurt. Non-cognizable offenses. Like for simple hurt, police cannot go there, like immediately tie and arrest and everything, right? They need a warrant. They need a proper warrant to go ahead. Okay. Next, we have bailable offenses and non-bailable offenses. Bailable and non-bailable. Now, what do we mean by this bailable and non-bailable? Again, can the police at their level itself give bail or not? So, in case of bailable offences, the police can give the bail. Again, here example would be a simple hurt. Not it's a simple thing, right? It's easily given bailable. Not much is involved in that. Next, for a rape or a murder, the police cannot give the bail just like that. They have to go to the magistrate. The magistrate has to decide based on the weightage of the case, right? Next, can the people compromise outside or not? கட்ட பஞ்சாயத்து வைக்கலாமா வைக்கக்கூடாதான்றது, ரைட்? கட்ட பஞ்சாயத்து வைக்கிறோமா வைக்கக்கூடாது. Now, compoundable and non-compoundable. Compoundable அப்படின்னா they can finish the issue outside the court easily. Non-compoundable. Non-compoundable means, like when they say there is non-compoundable offense, they cannot solve the issue outside the court. Again, example, rape, murder. People cannot just pay money outside the court, finish off, compensation done, nothing like that, right? So they have to come to the court. Murder and rape. Okay, so again, this they have given as a particular offense and they have asked whether it is cognizable, non-cognizable and everything. See, you cannot remember the whole list. Okay, so whole acts and what is compoundable, non-compoundable, we cannot. Keep a simple idea as to it. That's all. They give some offense which is so heinous, like rape, murder, right? All these of it will be a cognizable offense. Police can arrest பண்ணலனா ஓடி போயிருவாங்க, right? People will run off. It will be a cognizable offense. Non-bailable, police cannot give the bail, and it will be non-compoundable. They cannot finish the case outside the court, right? Take criminal abortion, right? Criminal abortion, death of the woman happens, they give you the history like that. Then what do you say? Again the same thing, right? Arrest has to happen, police cannot give the bail, compromise cannot happen outside the court hall, right? Now, this is with respect to offenses. Now, let's see the trial. Trial, they have maintained the same thing, right? Now, you have two types of trial. One is a warrant case and another is a summary case. Now, what is a warrant case is whenever the punishment is more than 2 years, it's called as a warrant case. Any offense which has a punishment for more than 2 years, we call it as a warrant case, which means the proper procedure has to be followed. A charge sheet has to be filed. The moment the charge sheet is filed, it has to be read out to that particular accused also and to the person who has filed the complaint. A proper trial has to happen and then only the judgment can be given. Now, summary cases are any cases other than warrant cases, which means less than 2 years punishment is there, means it's called as summary cases. Take a petty offense. People, like, in a heat of moment, slapping each other, simple theft. All of these are all considered as summary trial, which means the judge can always call, ask what it is, give the punishment, finish off the case. So these are all summary trials. Even motor vehicle tribunals have summary trials. If you have been like caught for skipping a red light or something, they will just say like, fine, finished. Yes, you have not crossed it. They will ask you out. If they think that you have not skipped the red light, then they would say like, go. Else, they have a camera proof, everything, pay the fine, go off, right? So those are the types of trials. Now, let's try answering it. Again, try to answer in the chat box so that, like, one is you are engaged and another thing is if you go wrong, it is okay, right? You'll at least know that, okay, I'm going wrong, I have to correct it. Okay. What type of offense has been committed by Mr. Don? We took our history. There's a guy, he was murdered, right? Stabbed to death by Mr. Don. What type of case? Civil or criminal? Criminal. Very good. It's a criminal. Okay. Who will be fighting for Mr. Khadi in the court? Who will be fighting? It will be a state or will an individual? Yes, state. On behalf of the state, we can call that person as the public prosecutor. Public prosecutor, right? We call it as the PP. PP will fight. Yes, the state will fight. State will fight for the case. Okay, next, can police arrest without warrant? Can the police arrest without warrant? Good. Can police grant bail? Can bail be given? No. Very good, very good. Can Mr. Don pay some money and get out of it? No. Very good. What type of trial will be conducted? What type of trial will be conducted? Very good. Warrant case. Very good. Warrant case. Very good. Okay. Let's go to inquest. Again, from inquest, they always ask who can do what type of inquest. That has been asked. So let's look into inquest. One thing which I would like to start by making it very clear is inquest is inquiry into the cause of death. Anywhere in the question or in the option, magistrate does inquest in all of the cases except, and they have given gang rape. Okay. Now remember, gang rape, when we say the death has not yet happened, the person is still a survivor, right? Which means an inquest is not needed. If they say death as a result of gang rape, again, magistrate need not be involved in all gang rape cases. Okay. So when we say inquest, remember that death has happened. This is very important. Inquest is inquiry into the cause of death. Okay. Inquiry into the cause of death. Death has to happen for us to conduct a inquest properly. Now, we have two types of inquest in India. Okay, so in India, we have only two types. One is the police inquest and another is the magistrate inquest. Okay, so in India, we have only two types, police inquest and magistrate inquest. Okay, now let's look into police inquest. Police inquest previously was dealt in 174 IPC. Today, we deal it in 194 BNS. Oh, sorry, these are procedures. Sorry. CRPC. And what will be there? 194. Instead of CRPC, today we have what? What do we have on place of? Yes, BNSS. Okay, very good. BNSS. See, because we are talking about the procedure, how it has to happen. So it's CRPC. Okay, the magistrate inquest was dealt in 176 CRPC. And today we deal it in 196 BNSS. Okay, they rewrote the whole CRPC. So, of course, the sections got pushed up, pushed down, and different ways. Okay, let's start with police inquest. Okay, whenever there is a call to the police that a death of a person has happened and this death has been caused by another man or a machine or an animal, it's a suicide. Or there is some query, suspicion is there. All of these cases, the police will first go to the place where the dead body is found. The police will first go to the place where the dead body is found. Okay. Now, this is important for us to understand because let's say a guy is murdered and then thrown in the river. The dead body is found 5 kilometers down the river. Okay. Now, one person calls saying that in a particular area, I am getting a call saying that I heard a gunshot. This is where the offense has happened. And another guy calls 5 kilometers down the river saying that, like, I see a dead body, right? Now, the police first has to go to the place where the body is found. Okay. So that's the important part. That is why even in suicides or in deaths where people have been thrown from a building and everything, you will see that the police is first always down. They will take care of the body, they will preserve the evidences that's there around the body, take the body, send the body for autopsy, okay, and then only they will go for the upper examination. If they have a bigger team, lot of people are there, then of course upper examination can also happen simultaneously. Okay, next, magistrate inquest. In India, we have two types of magistrate. Again, this has also been asked. We have executive magistrate. We have executive magistrate and we have judicial magistrate. We have executive magistrate and we have a judicial magistrate. Whenever we say executive, we are talking about subdivisional magistrate, SDMs we call them as, right? Why I'm telling you this is they've asked once, instead of asking directly which magistrate will be doing, in this case they have asked subdivisional magistrate will do inquest in, right? So you have SDMs, you have collectors, some states appoint Tahsildar. All of these people will form as executive. The state has the rights to appoint the executive magistrate. Now, executive magistrate will do autopsy or do the inquest in cases of death due to dowry. That is suspicion under 7 years of marriage. Exhumation. All this case will be done by the executive magistrate. Now let's take up judicial magistrate. Judicial magistrate is also important to us because whenever there is a death in custody or a rape in custody, okay, death in custody, rape in custody, disappearance in custody, all of these cases judicial magistrate will come in. Now, why is this important for us and why did they change it? Is again, you understand why so that you never forget it. Previously, what happened is executive magistrate used to do all these cases, dowry, exhumation and custodial death. All of these used to be done by executive magistrate. Now, remember, executive magistrate and police are working every day on a very close basis, right? So that's why the judicial magistrate had to come in between. Now, the judicial magistrates are the ones who sit in the court. They come out and they do the inquest in cases of death in custody, clear cut case. The patient is the person is there in custody, dies under the custody of the police, custody of the court, inside the jail, death in custody. A female comes, raped in the police office and then goes back to her home, commits a suicide. It is rape in custody. Though the death has happened at her home, it is rape in custody, right? Case scenarios come like that, rape in custody. So you see, rape in custody, judicial magistrate will come here. Disappearance, police says that the guy has run off, right? Police says Don has run off. 2 days later, Don's body is found in a river, right? Now that's considered as disappearance from custody. So rape and disappearance need not be that the death happened inside the custody. Even if the person has died outside, you considered it as a judicial magistrate inquest. Okay, now apart from it, we have two more types. Coroner's inquest, not done. The other name for coroner is prosecutor fiscal system, not done. Okay, we have only police and magistrate inquest. Now, who is a coroner? Coroner is a lawman. Okay, or you can call him as a legal man. So he is trained to conduct an inquest. We have this particular set in UK which is practiced and few states in US. Okay. Next, you have medical examiner system. Medical examiners are no one other than the forensic pathologist. Now, in India, we study forensic medicine directly. In foreign, they have to first study forensic pathology and then it's an expert in pathology, that's forensic pathologist. Okay. Now, forensic pathologist will conduct the inquest. It is considered to be one of the best system. and it's done in few states in US. It's done in few states in USA. Okay. Okay. Let's go ahead. Let's see the witness and evidences. Who is a witness? Witness is a person who has a first hand knowledge about the case. So he has a first hand knowledge. Okay. Now, he has a first hand knowledge about the case. It can be two types of first hand knowledge, right? The person has seen the thing and he's seeing it as a murder, right? I am seeing a person stabbing another person. That's kind of a directly I'm seeing, right? Or I'm doing an autopsy. I am seeing the injury, right? I am seeing the injury. So I still have the first hand knowledge, but the difference is this. Now, when we say common witness, they are layman. Sometimes doctors are a common witness, which means I go and I just saw murder and I tell like, okay, I am a layman. I just saw murder. Now, I did not see the murder. Police brought for the autopsy. I saw a stab wound and it was in the back. And there were multiple, right? There were multiple stab wound on the back, right? First, I realized it's a stab wound. I found out that it's multiple. I found out it's during the antemortem period. I found out which is the fatal wound, right? And I give my opinion based on my skill and knowledge, right? I give an opinion. I interpret the findings that I give. I am an expert witness. Okay, I become a expert witness. Yes, doctors are predominantly expert witness. At times, they are also a common witness. If you see someone doing a pickpocketing, you are a common witness. If you see some injuries which are there, which are suggestive of they have just dragged a watch from the hand, you just see that aberrations and everything, you become an expert witness. Okay, so witnesses can be both type of. Now, witness have to go to the court. There are some exceptions, right? Now, this question has also been asked. This they have asked. They have asked saying that who is an exception to go to the court as a oral witness? And one of the option they have given is doctors. Immediately everyone thought like, oh, doctors need not go to the court. No, we have to go to the court. Who are all exceptions are FSL, forensic science laboratory people, which includes their chemist, right? Ballistics, document experts, fingerprint, okay? Their voice recognition experts. A lot of their experts become an exception. And apart from it, mint officials. Mint officials means people who are involved in, money minting process. In government, there are press, right? Like for the rupees and everything. They all are an exception. Now, again, think about it. We as doctor, we are seeing an injury and we are interpreting it. Now, for an FSL, the lab gives the report. A machine today gives the report as to what my water bottle contains, right? Whether I'm having the right amount of nutrient in the water, whether there's any arsenic, lead or anything. A machine is giving the report, right? Chemist, that's why they are not called. A ballistic expert. They are called until and unless there is some contrary or the opposite party wants to ask a question. Else they are not called. They are called only when the opposite party wants to ask a question. Why? Again, you have two things, right? I have this pen and I have an Apple pen, right? Doesn't match at all. Now I have two Apple pen. I see it under microscope. I see like, what is the wear, tear, make, name, everything. I do a comparison microscope, take two pictures, put it as a part of the report itself. there is nothing to ask much, right? To say that two Apple pens are produced by Apple company, not much required. So that's why they don't call. Similarly goes for the document experts. They have a scientific background applied with the help of machines too. Whereas we as a doctor, we see something, we interpret it. What we interpret today might even change for us itself after 10 days based on our knowledge and expertise, right? So that's why we are called to the court. Okay, mint officials again are not called to the court on a regular basis. Okay, let's go to evidence now. Evidence, again, we have a separate act for it just because we want all our evidence to be admissible, right? It has to be allowed, and it has to be very important, it has to be relevant, right? It has to be a admissible evidence and it has to be a relevant evidence, right? It is a fact which is. Now we have two types of it. We have oral, we have documentary. We have a oral evidence and we have a documentary evidence. Now, apart from it, oral evidence can be of two types. One is a direct and another is indirect, of course. Now, let's start with our direct evidence. Direct evidence means the person has seen the offense or they have seen something, right? Direct. Indirect, now you remember again, like we are talking about someone seeing something. Indirect can be two types. It can be circumstantial or it can be hearsay, right? Now, what do we mean by it again? Circumstantial means I did not see a murder, but instead I saw someone running in front of me with a knife and that knife had blood or a red color stain. I did not see a murder, but today morning when I got up and came out, I saw my neighbor washing a blood stained cloth. Circumstantial evidence. Okay. Now, seeing a knife is a circumstantial evidence. Seeing a bloody cloth, circumstantial evidence. Hearsay is I did not see anything. Morning I woke up, my neighbor comes and tells me that like so and so was running with a knife and everything. Now that's a hearsay evidence, right? Hearsay evidence, remember, it's important to know that not allowed in court. Not allowed in court. She told me, he told me, no. Okay. Hearsay is similar to a gossip. That's why they don't allow. Interpretation can change, right? So that's why it's not allowed. Okay, now let's look into our documentary evidence. Now, documentary, when we say, we are not just talking about written documents, in the book or like, a written document in the iPad. No, we are also talking about the CCTVs, right? So documentary evidence today includes, okay, written, electronic, and remember when we say electronic, it also includes not only your again written but also your AV, audio and video also. Okay, it includes audio and video also. Okay, what all can be allowed in the court? They can, for us, for doctors, they can allow any of our certificates, any of our reports, any of our case files. Writing at the bottom of a case file saying that this is not for medical legal purposes is of no use at all. Any case file can be used for court as an evidence. Okay. Then you have dying declaration. Dying declaration, again, an important area where they have asked questions. Previously, we had it under Section 32 of Indian Evidence Act. Okay, now today we deal it under 26 of Bharatiya Sakshya Adhanya, BSA. Okay, 26 deals with it. Now, dying declaration, there are two things we have to know the difference about. Dying means the person is expected to die. Death is happening. Declaration means he is making a statement. Declaration means it's making a statement. Okay. Now, who can record it? Magistrate are ideally supposed to record it. Now, after that, it's the doctors and then the police. So that's why recently you can see courts which are again and again asking doctors that, why didn't you record it? The magistrate was busy. The magistrate was not able to come. The distance was pretty high, right? In peripheral areas and all, the distance between the court and the hospital is pretty high and the magistrate cannot come right now. So the second best person is the doctor, not the police. Okay, the system trusts the doctors more. Now, even if the doctor is not there, roadside, there is an accident, the guy wants to give a statement, then it's the police who takes care of it. When should it be recorded? When it should be recorded means when the person is having compos mentis. Compos mentis அப்படினா தெளிவான நினைவு, right? Which is nothing but when you write fit for statement, then you can record it. Okay, so compos mentis has come as an option. Compos mentis, composed mental state of mind, right? Compos mentis. Okay, what is the procedure for recording it? Record when the patient is conscious. Okay, ideally the person should write. Person should write and sign. Okay, with witness being there. Now, if the person cannot write, if the person is not able to write, someone else can record it. Okay, so they are recording and read back. I have recorded it, I am reading it back, right? Record and read back. Then you get the sign with witness, of course. Any time during this, if the patient becomes unconscious, you record that the patient has become unconscious and sign it. That's all. Wherever the patient stops talking, you say that till here the patient was conscious, oriented and was alert. You write down whatever he has said, sign it, stop it there. When is it allowed in court? It is ideally allowed only after the death of the person. Or remember also that if the patient is going to be in a coma state, then also it is admissible in court. When the person is not able to come or the patient is unconscious, if the person has died, then you are allowing it in the court. Okay, now what if there are more than one? Okay, what if there are more than one? The last statement is considered as the true statement. So the last statement is considered the true statement. But having said all those things, it's important to understand, just because A said B murdered him, it is not that B is immediately arrested. The whole dying declaration has the value similar to that of a statement to the police. So if a guy comes and says that I was stabbed to death and the knife was brought by my neighbor, the police has to go to the neighbor's house, find there is a knife and that knife is bloodstained and everything. So it's just a statement given to the police. It is allowed only when there is other circumstantial evidences towards it. Classical case of dying declaration, which we always discuss, is this: a female was set on fire by her in-laws. First time when she came to the hospital, she's coming with severe burns. She comes to the hospital, tells everyone that, like, my husband and my mother-in-law set me on fire. Now, day one, the husband and mother-in-law comes and they say that, like, see, you have kids. If you tell the police and everyone that we did it, we are going to make sure that your child pays for it. You are going to anyway die. We will trouble your child. So you better take back the statement. So the second day, the female took back the statement and she said, like, while she was cooking, something went wrong and she caught on fire. Now then the third day, NGOs came in. NGOs came and said, see, your in-laws are not going to take good care of the children. We will take care of your children. Tell what was the truth that happened, right? So then she said again the in-laws were involved and everything. Now with this statement, it is the last statement that is given. She died. With this statement, the police then went behind, did inquiry, found out that they bought kerosene, they bought these stuffs, and this particular time the door was closed. So it's a statement that is given, and it is the last statement that was given that was taken into consideration. Okay, so that is dying declaration. Dying means it's about their death they are talking, death is going to happen, and they are giving a statement. Now, next you have dying deposition. Dying deposition. Deposition means there is court involved. Then only you use the word deposition. When court is involved, you use the word deposition. So what does this mean? Here, you are going to have someone who is going to take oath. Right? Unme solren solano, right? Oath is taken. Opposite side party comes in. The opposite side lawyer will come. They will cross-examine. The judge will be there. Judge will also ask question in between. So if you see in this foreign movies and all, where the judge will come, will stand inside the person's terminally ill person's bedroom, and they will ask the person to take an oath. They will ask some cross questions. They will do the examinations. All of that is done in dying deposition, not in dying declaration. So dying deposition is not allowed in India, or not present in India, we can say it. Okay, it is not done in India. Okay, because in India, a passing soul is considered to be a sacred, so they don't bring court and everyone inside the place. Okay, in India, no oath, no opposite side lawyer, no cross questioning and all. Just clarification can be asked by the doctor or the magistrate who is writing the statement. No judges and all presenting and telling, okay, this is correct, this is wrong. No, nothing like that in India. Okay. Okay, let's look into the chain of custody and destruction of evidences. Okay. Chain of custody means, first remember, it's a document. It's a document which tells what happens to the evidence from collection to being produced in court. Okay, now how they have asked questions with respect to chain of custody is this. One of the statement they would give saying that the knife while transporting tore the bag and fell down, right? Chain of custody is broken there. Okay, so you document what has happened. It has to be in a sealed proper way that the evidences are handled. Okay, evidences are handled in the sealed proper way. Next, you have destruction of evidences. Destruction of evidence is previously was dealt in 201. Okay, now 201 IPC was telling that, like, if there is a destruction of evidence, we are going to give punishment for like this and everything. Today you have 238 BNS. Okay, Now, again, this is coming up in court. Recently, also, there was a judgment in which the doctor did not preserve blood for alcohol in a case of drunken drive. And the doctor said he did not know that a sample has to be collected and sent and everything. The court did put fine on doctor, about 5,000 rupees fine was put, saying that a doctor should have a basic knowledge as to that forensic evidences have to be collected. Sexual offense evidence collection, drunkenness evidence collection, doctors should know it, and failing to do so is considered as destruction of evidence. See, when we say destruction of evidence, we are meaning that the person is a part of the crime, right? The person is a part of the crime. That should not happen. Okay, let's do a quick recap. Yes, can we see this? Who will conduct the inquest for the death of Mr. Caddy? Who will do the inquest? Very good. Police. Try answering. Okay, police will do the inquest. Okay, now let me ask you questions slightly twisted. Gang rape and death. Who will do the inquest? Gang rape and death. Who will do the inquest? Gang rape and death. Police only will continue to do the inquest. Female raped in custody, went home, commits suicide. It's a suicidal death. Who will do the inquest? Judicial magistrate. Yes, judicial magistrate. Very good. Judicial magistrate. Good. Okay. A person who is buried, okay, legally buried, proper cremation, has to be removed and autopsy has to be done. Who will do the inquest in such case? Executive magistrate. Very good. Executive magistrate will do the inquest in such cases. Okay. A person who was in a bail outside dies. Who will do the inquest? The person is on a bail. A person is on a, yes, judicial magistrate only, because a person who is on bail is still in custody. Okay, he's still in custody. Okay, very good, very good. Okay, now question number 8. Under which section will the inquest be conducted? Very good, you told that. 194 BNS. List of witnesses. Who all can be the witness? Who all can be the witness? Buddy is a witness. Very good. Buddy is a witness. Anyone else? Yes, the doctor. Right? Dr. Watson, the doctor is a witness. Okay, what type of witness is buddy? What type of witness is buddy? Common. Very good. What type of witness is doctor? Expert. Very good. Okay, evidences. Can you think of all the evidences? All of you try to answer. So when you try to answer, even if you're wrong, you come to know about it. Evidence, yes. Knife is evidence. Bloodstained, yes. In shirt. Very good. Okay. Good. Yes. Also remember, the oral statement given by the buddy is also an evidence, right? He's going to come and tell in the court. That is also a evidence. So oral statements, don't forget it. Oral statement is a evidence. And what will the doctor give us as evidence? Autopsy report, right? Autopsy report is also going to be a evidence. Okay. Now, oral statement given by buddy, what type of evidence it is? Oral statement given by buddy, what type of statement it is? What type of evidence? Direct, yes, it's a direct evidence. Yeah, it's a direct oral, right? Yeah, very good. Okay, ma'am, can you explain bail? See, whenever we say a bail has been given, the person is still under arrest only. It's just he can freely roam around in the premises that has been given. That's why whenever a person is on bail, they are supposed to come and sign and everything. So a person in bail is actually in custody. So that's why if their death happens, the judicial magistrate inquest will kick in. Okay, Dr. Divya? Yeah, let's continue. Okay, let's continue. We will take a break at 11 o'clock. We will take a break at 11 o'clock. Okay. Yes, courts of law. In India, the toppest court is Supreme Court. So let's start with that. The toppest court is Supreme Court. After the Supreme Court, state levels, we have high courts. And after the state level, district level, we have sessions court. District level, we have sessions court. Okay. Okay. Then you have magistrate courts. Magistrate courts in metropolitan cities are called as metropolitan magistrate courts, and there are special courts. Special courts means for juvenile courts there are separate, for family courts there are separate, to determine educational you have separate, labor you have separate, motor vehicle tribunals are there, national green tribunals are there. So there are special courts which are separate, right? Okay, now let's look into each of these. The Supreme Court is the highest court. They generally receive only appeal cases. Sometimes they do take cases when the constitutional rights of a person is questioned. Okay. And whenever there is a state and they are fighting with another state, then they do take up these cases directly. Okay. But it's mainly a appellant court. Same goes for High Court also. Same goes for High Court also. It's an appellant court, except when there is a constitutional right or a state versus a state issue, they will not interfere. Okay. Now we come to the Sessions Court. Sessions Court is important. They have asked questions with it. Okay. Sessions Court has two people. DSJ, District Sessions Judge. Additional District Sessions Judge. Okay. They both have the same power. They both have the same power. The power that they execute is they can give death sentence, which is the capital punishment. Okay. They are the lowest court which can give a death sentence. Okay, they are the lowest court which can give a death sentence. Okay, so Sessions Court can give a death sentence, but this death sentence has to be approved by the higher court. So the question that they have asked twice is, which is the lowest court that can give death sentence? It's the Sessions Court that can give the death sentence, but this death sentence has to be approved by the higher court. The lowest court which can give is Sessions. Okay, they can give it, but it just requires approval. That's all. Then you have assistant. Assistant is assisting. It's next post. It's lower than the additional or district. District Sessions Judge and additional District Sessions Judge, they both can give death sentence and capital punishment. Okay, they both can give death sentence and capital punishment. Okay, now in magistrate court, you have three people: chief, first class, second class judicial magistrate. Now, a second class judicial magistrate, see, let's go with first fine. 5,000 rupees he can give up to. First class, up to 10,000 rupees they can give. Then you have the chief additional, unlimited. Any amount of fine can be given by them. What about the years? How many years of imprisonment they can give? A second class can give 1 year, first 3 years, 5 years, and then here you have 10 years. Okay. They can give punishment of 1, 3, 5, 10. Okay. Then you have special magistrate. Special magistrates are juvenile, and your special magistrates are also going to deal. Okay, your special magistrates are also going to be there for Motor Vehicle Act, National Green Tribunals and other places. Okay, now let's look into the capital punishment. See, when we say capital punishment, we are talking about death sentence. Okay, we are talking about death sentence, death of a person. Okay, we are talking about death of a person. 416 CRPC, which is now 456 BNS, says when the person is pregnant, when the person is pregnant, the death sentence has to be delayed. The person's pregnant, then the death sentence has to be delayed. Okay. So this is how the punishments are given. Let's devise through it. Supreme Court, High Court, unlimited fine, unlimited years of imprisonment, and death sentence also they can give. Then you have Sessions Court, right? And in Sessions Court, you have two people. One is the Sessions Judge and the Additional Sessions Judge. They have the same power. Then you have the Assistant Sessions Judge. Assistant Sessions Judge can give only up to 10 years of imprisonment. In metropolitan cities, you have, or metropolitan magistrate court. Else in other areas, you have magistrate courts. Magistrate courts start from the lowest, second class, first class, chief. Second class can give 1, first class can give 3 years, chief can give 7 years, and the fine is second class and first class alone have 5,000 rupees and 10,000 rupees as the fine. Death sentence is also known as capital punishment. I am telling you this because capital punishment is given by, they have asked. Capital punishment means death sentence. And in capital punishment, pregnancy, if the female is pregnant, then till the delivery of the child, the death sentence has to be postponed. That is what the section gives. After that, if the female wants, she can always ask for a plea. Okay, she can go to the governors and she can go to the president. Okay, and she can say that please do take off my death sentence. Okay, let's go for recording of evidence. Recording of evidence. Now everything is done. Autopsies are done. We are being called to the court, right? We are going to go to the court. The first thing that we will receive is a summon. Summon is also called as a subpoena. A paper, that's again, so which means a document, right? It's a document delivered saying that, okay, you have to appear at this particular time at this particular place. So it gives the time, place, and what all you have to carry with you. So if you have to bring a document, they tell bring the report. You're called for this particular purpose. Okay, so that is a summon. Okay, now summon was previously dealt in section 61 to 69 of IPC or CRPC. Which one will deal summon? The procedure as to how we are supposed to receive the document, when they are supposed to give the document, if we don't come, what they have to do. Very good, CRPC. Okay, now it was dealt in 61 to 69 CRPC, but today we deal it in section 63 to 71 BNSS, Nagrik Suraksha Sanhita. Okay, BNSS, they deal with summon. Okay, now you have multiple summons. You have a summon from lower court and you also have a summon from high court. Same date, same time. Okay, which one will you go to? You will go for a higher court. You have a civil case and you have a criminal case. Which one will you go to? Criminal. You have two courts, same cadre. Okay, let's say you have Delhi High Court and Chennai High Court. Both of them are calling you on the same date, same time. Case both are criminal only. What will you do? Go to the one that gave you the first summon. And always, whatever is the case, inform. Okay, inform the other court that you are not able to come because of so and so reason. inform the other court. Now, what is the punishment? The court can first issue a warrant. Remember, they can directly issue fine and other things also, but they can issue a warrant. But even before the warrant, they can give you a notice, a warning, okay, and then of course make a arrest based on this. Fine, again, based on the type of offense. It's not as easy like 500 rupees, 1000 rupees. The fine is again based on type of case also. Okay, next, oath. Oath is nothing but a promise. Who need not take it? A child less than 12 years of age need not take it. Okay, a child less than 12 years of age need not take it. Now, what is perjury? Perjury is false or lying under oath. Lying under oath is called as perjury. Lying under oath is called as perjury. Okay, now, perjury can be of two types, right? One is lying under the oath with the intention to hide something, or lying under oath without knowing what they are telling itself, right? Now, when the person lies under oath with the intention to hide something, then it becomes punishable. Okay, so that's why they defined perjury separately in 191 IPC. So everything requires a voluntary intention also. Perjury is an offense which requires voluntary intention also. The definition is given in 191 IPC, which is today in 227 BNS. Okay, that gives the definition. The punishment is given in 193 IPC, which is 229 BNS. Okay. Now, how much punishment they can give? They can give up to 7 years. So, lying under oath, up to 7 years they can give. Now, since we are discussing perjury, also remember issuing a false certificate, which was previously dealt in 197 IPC. Today we deal it in 234 BNS. False certificate. Okay. Now, here what do? They make it very clear and they say that the punishment is going to be up to 7 years. So that's why again and again nowadays we are seeing cases where false certificate, doctors are being called up and they are being asked as to what has happened. Okay. Okay. Hostile witness. Hostile witness. Now, so there is a difference between perjury and hostile witness. Hostile witness is a person who gives evidence against his own party. Now, if a person gives evidence against their own party, they are called as hostile witness. They give evidence against their own party. They are called as hostile witness. Okay. Okay. Now, the interesting thing in hostile witness is this. Remember, need not be all hostile witness is perjuring. A classical example is again a real-time case was this. A forensic expert got a part of the bullet. So let's say he got only a part of the bullet. And now when he saw the part of the bullet and they told him to match it with a weapon, he said, I couldn't match it. Maybe probably this is not the weapon that was used because he couldn't match it properly. Few days later, the police brought the whole bullet. Rest of the bullet was also found in the car or the crime scene and they bought it. And now when he put it together, he said like, yes, this bullet is fired from this particular weapon only. Now he's shifted from one party to another party, right? Previously the defense was calling him, now the same side party was calling him. So he said, like, this is what has happened. He's a hostile witness now, right? He's a hostile witness now, but that doesn't mean he's perjuring. Perjuring is giving false evidence knowingly. He is not giving a false evidence. He's giving the truth evidence. What was with the knowledge that was there available before? What was is the knowledge available today? So remember, hostile witness need not be, they are always perjuring. They give line items. Hostile witness are punished under this particular section, always, need not be. Okay, this particular section always, need not be. Okay, okay. Now let's look into how we are going to be examined in the court of law, right? First is going to be examination in chief or chief examination, right? This is also known as collection of statement. Collection of statement, right? Now, what is happening? I am going to the court, the party which has called me, right? In most of our cases, it used to be the public prosecutor. The same side party will ask us question. See, now here they will just say, doctor, tell us what you found in this particular case. Then I start by saying, I am so and so, I was working here so and so during this particular time, now I am working here so and I did this particular autopsy and these are the findings that I did. Now you tell that that is examination in chief or the chief examination, or you call it as the collection of statement. First time done. Then comes re-examination, cross-examination. Okay, so 2 should be cross-examination. Now, what happens during cross-examination? During cross-examination, the questioning is done by the opposite side party. Questioning is done by opposite side party, right? Now, what do? Here they ask something called as the leading question. Leading question. They ask leading question. What are leading question? Leading questions are yes or no type of question. It is a yes or no type of question. Example, the opposite side party will come now. Now the opposite side party will come and they will ask, doctor, is this possible that this person died due to the hospital infection? See, he met with an accident, he came to the hospital, stayed, developed a hypostatic pneumonia and everything. So it's a yes or no question that they will be asking, right? Now, hospital acquired infection due to immobilization, due to road traffic accident, right? But they have left the road traffic accident. They are just asking a yes or no question. That is why it's called as leading question. It's a very tricky question. Now, I go for re-examination. Now, the re-examination is done by the same side party. Now, this is for clarifying. And here, leading question is not allowed. Here, leading question is not allowed. Now, what do we mean by this? The initial examination, I told that there are road traffic accident injuries. These are all the findings. Patient stayed in the hospital, later developed infection and died. In cross-examination, the lawyer came and he asked, did it happen due to hospital infection? Did it contribute to death? Yes, it did contribute to death. Now in re-examination, they will clarify it. They will ask like, okay, can you tell us about this infection? Then you say that the infection would never have happened has he been at his home. This happened because he met with an accident and this accident led him to become to the hospital, and in the hospital he became infectious. That's all, right? He became prone for infection. That's all. So this is what is re-examination. Re-examination, same side. It is for clarifying. No leading question is allowed, but you can clarify. Apart from it, remember at any time during the course, you can volunteer. Let's say in the re-examination, they didn't clarify. You can always volunteer and say, right? Now, question by court. Question by court is judge. Remember, judge has power. He can ask any question, any time, relevant or irrelevant? Okay, now this is important for us. In the court, we cannot sit and say that like, oh, you should not ask me this question. What I ate in the morning is not. No, they can ask at any relevant or irrelevant question. That's the power of the judge. Okay, and the judge decides whether the question asked by the same side party and opposite side party are relevant or irrelevant. Okay, okay, let's go to the ending part of it. Now comes the ending part of it. We have finished conduct money. Conduct money is the money that's paid to the witness in civil cases only. Now, what happens to criminal cases then? Now, in criminal cases, you can get a TA and DA, travel and dietary allowance. It's given by the court. Again, may or may not be given by the court, because we all as citizen of India, we are supposed to go and give evidence, right? Okay, so in criminal cases, TADA is given by the court. If we are government employees, the government can pay us also. Yes? Okay, then you have burden of proof. Who will prove what? The burden of proof that the crime has happened, right? Now this is where we will be again discussing about corpus delicti, essence of crime. First, there has to be a crime and someone has to prove that there is a crime that has happened and so has done it, right? It is always on the person who is accusing it. It is always on the person who complains. That's why even in medical negligence, if the patient complains there is negligence, it's the patient who has to prove that there is a negligence. There is always an exemption, but it is on the complainant. What is the standard of proof? Standard of proof for civil cases and you have for criminal cases. Now, in civil cases, whenever there is reasonable doubt. Now, what do we mean reasonable doubt? 50-50% chances. 50-50% chances punishment can be given. Criminal cases, there is beyond reasonable doubt. Beyond reasonable doubt, which means 90% above, there should be no doubt that this particular person has done the offense. That is the standard of proof that they expect. Okay. Now, we will revisit this examination again. I go to the court, chief examination by the same side lawyer, cross examination by the opposite side lawyer, right? Re-examination by the same side lawyer, re-cross examination by the opposite side lawyer. See, whenever the word cross comes, it is the opposite side lawyer. Okay, cross comes, it's the opposite side lawyer. Okay, yes. Which court will conduct the trial of Mr. Don? Let's answer. Which court will conduct the trial of Mr. Don? Yes, criminal court will conduct it. Who can ask the leading question to the doctor? Leading question is asked by whom? Opposite side. See, always remember the word opposite side. The Lord, we are called to the court depending on what we write in the report, right? If my report is not in favor of the PP will not call me. My report is not in favor of the defense will not call me, right? It depends on like who it is. It's the opposite party. Opposite party to us sometimes can be defense, sometimes can be PP also. Predominantly, it's the defense. That's the thing. Will conduct money be given? Will conduct money be given in this case? Very good. No. Standard of proof that is required is? Standard of proof? Yes. More than 90%. Beyond reasonable doubt. More than 90%. Beyond reasonable doubt. Very good. Okay, now let's recall on a very fast basis. We saw what are criminal cases. We saw the difference between cognizable and non-cognizable offences. With example, just let's look into it. Rape is a cognizable offence. Rape is a non-bailable offence. Rape is a non-compoundable offence. So when we say cognizable, we are talking about whether the person can be arrested or not without warrant. Okay, so we are talking about arrest. Bail means whether we can give a bail or not. And when we are talking about compoundable, non-compoundable, whether they can settle outside the court or not. Okay, outside court settlement is allowed or not. Okay, now warrant case, summary case, the cutoff is 2 years. More than 2 years means we call it as warrant case, right? It has to go through the trial procedure proper. Okay, when then we have police inquest, we have magistrate inquest. We have police inquest and we have magistrate inquest. Police inquest is done in almost all cases. You have it today in 194. BNS, magistrate inquest. Magistrate inquest, MCQs have come on and off. You have two type, judicial and you have executive. Executive includes your subdivisional magistrate, collectors, tahsildars and everyone. Okay, and in judicial magistrate they are going to consider with death, disappearance and rape in custody. Death, disappearance and rape in custody. Other types of inquest that's done in foreign are coroner and medical examiner. Right? Witness is a person who has first-hand knowledge. Okay, who is a hostile witness? Hostile witness? Hostile witness? Who is a hostile witness? Evidence against his own party. Okay, so this is also important. And then we saw the type of evidence. In evidence, we saw types of evidence. The important part is also your dying declaration. Okay, questions have been asked about dying declaration. Dying declaration is allowed in India. Okay, dying deposition is not allowed in India. Dying deposition is not allowed in India. Yes. Thank you, Dr. Anish. Yeah, thank you, Dr. Preeti. Yeah. Chain of custody. Chain of custody is, we are talking about which one? We are talking about the evidence. Chain of custody means we are talking about the evidence. Okay. Then you have summon, right? Then you have summon. Okay. Now, summon is a document that warrants the doctor to come at a particular time at a particular place. With a document, without a document, they can ask us, like, bring a copy of your evidence, all of this, right? So that's asked. Okay, then you have perjury. Perjury means giving false evidence. Giving false evidence. Leading question is allowed in cross-examination. Leading question is allowed in cross-examination. Your appeal court, purely appeal court, are your Supreme and High Court. But also remember, your sessions court can come in. Like if the magistrate court judgment is not satisfied, people come to the sessions court. Then they go to the High Court. Then they go up like that. Okay. Burden of proof. Burden of proof is always with the person who does the complaint. Okay. There's a layman law, which is like, it's so obvious. Then it will shift to the other person, which in medical we will see again. In the evening session, we will see that res loquitur. But right now, remember that the burden of proof is with the person who complains. Standard of proof depending on the civil and criminal. Right? use these recall pages thoroughly. Use these recall pages thoroughly. Okay, you have to again and again see through it. Yes. Okay, police inquest is 194 BNSS only. Magistrate is 196 BNSS. Okay, magistrate is 196 BNSS. Yeah. Okay, let's do some MCQs. Documentary evidence that needs oral testimony in court is called as? Is which one? Which documentary evidence requires oral testimony in court? Try answering. All of you try answering. You all have the book open in front of you, so please do try to answer. Yes, post-mortem examination. They can call us and ask, right? Dying declaration, there's no one to call. Only chemical examination, I told you it comes from a mission. They cannot ask anything. Fingerprint also the same. Today you have automated fingerprint identification system. So the role of experts to the court has decreased. Okay. Next, which of the following statements is false regarding an offense? Which of the following cases it's false regarding an offense? Yes. So when you read, please do be careful with the word false. Police needs a warrant to arrest all. It's a false statement. So let's discuss others also. Offense is anything that's an act of commission or omission, punishable, agreed. Bailable offenses are those in which the police can grant a bail. Out of court settlement is allowed in compoundable. Very good. Okay, next. Third one. Which of the statement is true about court procedure? Which of the following? True. They have asked true regarding court. Try answering. I can see only 6, 7 answers. Yeah, 4 is the correct answer. Okay, so also remember to see the others. Without exception is wrong. What is the exception? What is the exception we have? Less than 12. Very good. Less than 12 years. Very good. Examination in chief of a witness can be done by any of the two parties? No, it is the same side lawyer who does the leading question is asked only in cross or recross or judge. Okay, judge can also ask crossing. Okay, intentionally giving false evidence in the court is punishable under giving intentionally, wantedly giving false evidence. Very good. Perjury. Punishment they have asked, right? Very good. Can we recall this 191 is the, let's try the other ones also. 191 is the, yeah, it defines perjury. This one gives the punishment. $197 is for false certificate. Very good. Faster. And the last 201 or 238 is? 238 is for? Yeah, destruction of evidence. Of evidence. Which of the following cases inquest will be done by judicial magistrate? Yeah. Fourth, rape in custody. Very good. Rape in custody, it will be the judicial magistrate. Very good. Okay. Now these are plain pages, so I always give a blank page or a one-page note. So what we would request you is this: we finish this topic either during your break or at night. When you revise through the topic, make a note of everything that you understand from it. Okay, so this one page tomorrow, like this in forensic medicine, you will have like 15 pages. This 15 page prior to your exam, if you see, you should be able to answer. So this is for you to make your own notes. So do make notes of the legal procedure into these pages. Do not forget about fathers in forensic medicine. Fathers in forensic medicine have been asked. So make small notes in a way that you can understand easily. Okay.